All right, we're not going to introduce ourselves a second time, so whenever you're ready, you can start off with your personal statement.
Thank you. I'll just begin briefly introducing my family, my wife, Candy, my daughter, Allison, my son, Ian. My mother, Colleen, is behind my wife, and my sister, one of my sisters, Patrice, is here. I'm grateful for them here. I've also got former partners and friends that are joining us both online and here together with us today. All right, thank you for convening today for this confirmation hearing and for the opportunity to share a little bit about myself. Before I do that, I want to express, as everyone does, but I want to express my gratitude to Governor Cox for this appointment and for his confidence in me. I'd also like to thank the governor's team who's helped me through all the stages of this process, including Lieutenant Governor Henderson, Tom Ross, Daniel O'Bannon, Dan Strong, Liz Kelch, and Monica Taylor. And finally, I'd like to thank the members of the Third District Judicial Nominating Commission for their recommendation in the early stages of the process. I will pause here after listening to the Attorney General speak and to everything that was said about Amanda, that I am also grateful that there were 2 slots available and that I could tag along behind Amanda, because she's clearly very well supported and qualified for her position. I also would not be here without the support of my family, and that I just introduced to you. I won't look back there again or I'll become emotional. I did not disclose in the closed session, probably should have privately, that I'm an emotional person, and I will do my best to let that come out on the bench. But if you're gonna, as you'll see when I talk about my family, it's a little different story. You'll hear more about them in a minute, but suffice it to say they are my top priority, my top worry, my top love, and they always will be, regardless of what position I hold or where I work. The best way for you to know a little bit about who I am as a person is for me to quickly tell you where I come from and how I ended up in this seat here with you today. While I was born in Logan, Utah, I grew up just outside of Idaho Falls, Idaho. I'm grateful to have my mother, Colleen Williams, here with me today. My father, the only person that I consider a hero in my life, he passed away way too young in 2019. I'd like to think that he might be logged on and watching this from somewhere up above. He would enjoy seeing me go through this process, and he would especially enjoy seeing you grill me with your questions. I'm one of 7 children, 5 girls and 2 boys. Professionally, my father was a full-time seminary and institute teacher for the Church of Jesus Christ of Latter-day Saints. And my mother focused her time on raising her children, while also working part-time to help feed 9 mouths on a 1980s seminary teacher's income. From my parents, I learned faith, hard work, patience, listening, and compassion. I learned to be aware of and concerned for those around me who have less than I do, and to help and serve them whenever I can. I've tried to strengthen these values in myself as an adult, to teach them to my children, and to apply them as appropriate in my professional law practice. I served an LDS mission to southern France, and after my mission, I attended Ricks College in Rexburg, Idaho. There I met my beautiful and smart wife, Candy, who at the time may have been writing to and waiting for one of my former missionary companions who was still in France. There's much more to that story that I don't have time to tell you now, but needless to say, it worked out well for me, and we've been married for 31 years. After graduating from Ricks College, I finished my undergraduate degree in political science and Middle East studies at the University of Utah while working full-time for the LDS Church and its security department. A pivotal connection in my professional life came when As a result of a Hinckley Institute of Politics internship placement, I met former Attorney General Jan Graham. My assignment for the summer internship was to study the possibility of Utah joining other states and suing the nation's largest tobacco companies. At the end of the internship, Attorney General Graham asked me to stay on to work on her anti-tobacco policy initiatives and assist with the tobacco litigation and eventual settlement. Following the settlement, I joined her team full-time, and she expanded my responsibilities into other areas, including legislation important to the functions of the AG's office. Jan Graham was a remarkable woman and a very important legal mentor of mine. She's another important person in my life who also passed away way too early. In my mid-20s, she allowed me to join her in high-level meetings with Governor Leavitt, Speaker Marty Stevens, and President Lane Beatty as they fought and negotiated over how to use the proceeds from the tobacco settlement. And she never once asked me about my political affiliation or cared whether it matched hers. Before I ever thought about being a lawyer, she taught me about negotiating skills, fighting for what you believe in, while also demonstrating civility and respect for those on the other side of the political aisle or the courtroom. When she decided not to run for re-election in 2000, she told me I would be out of a job and that I should go to law school. That was the first time that I ever thought of becoming a lawyer. I went to law school at the University of Utah, and following law school, I worked for a downtown law firm of Snow Christensen and Martineau. I spent 17 wonderful years as an associate and shareholder at Snow Christensen, where I learned how to be a lawyer. I have too many friends and mentors from Snow Christensen to name them individually, but some of them are here and watching online today, and I'm grateful for their roles in getting me to this point in my career. In early 2020, at the start of the pandemic, I became a partner at the medical malpractice defense firm Campbell, Williams, Ferentz & Hall. Von Hall, Dave Ferentz, and Cameron Beach, who was in this seat a few months ago and is now a judge in the 8th District, and Jacob Nelson have been my partners and will be my close friends forever. I'm grateful to them and all of the paralegals and staff that I've worked with there and at Snow Christensen. As you've read in my materials, my career is focused on two primary areas. Primarily, I've defended healthcare providers in medical malpractice litigation. It's been my honor to represent many of Utah's physicians, nurses, and other medical professionals, as well as some of Utah's largest hospital systems, including the University of Utah Health, Intermountain Health, and what used to be IASIS Healthcare. Medical malpractice cases typically last multiple years, and jury trials go for weeks, not hours or days. In May of this year, while also navigating the application process for this position, my partner Von Hall and I went through a 3-week jury trial in the 3rd District. Through multiple jury trials like this and all parts of my civil litigation practice, I discovered my love for being in the courtroom. The second area of my law practice is much more personal and emotional. After 9 years of marriage and unsuccessfully trying to build a family, Candy and I were grateful to a woman named Brooke who made us parents by placing her new baby girl with us for adoption a couple of days after she was born in St. George. This momentous event occurred 1 week after I took the bar exam. And we had 3 weeks' notice that it was happening. The beautiful redhead sitting behind me was that blessing. 4 years later, another angel named Kendra blessed us with our son Ian after he was born. Ian is by far the best looking male in our family. Candy and I have a small family, but we have the family that God meant for us. and we could not have made it or had it without adoption. All four of us will forever love and be grateful for the extremely difficult sacrifices of Brooke and Kendra, and we remain very close to both of them to this day, as well as to Ian's birth father, who we first met a few years ago and who is influential in his life. As a new lawyer, when we adopted Allie, I felt an urge inside of me to use my legal career to help other couples build their families through adoption. Now, over 20 years later, I've become one of only a few lawyers in Utah that is subspecialized in complex adoption law. I have a collection of many hundreds of photos of families I have been honored to represent and play a small role in building. I've worked with legislators, including Senator Weiler, on adoption bills. I've testified multiple times before legislative committees and worked in many different ways to advocate for parents trying to adopt and for policies that promote healthy and ethical adoptions. Finalizing an adoption in court is easily the most personally satisfying part of my professional career, because every time I'm reminded of my own journey with Candy, Allie, and Ian. If I'm confirmed by the Senate, I very much look forward to continuing to help build families through adoption, albeit in a different role from the other side of the bench. I'd like to be a third district judge because I want to be in the courtroom. The courtroom, much like the rooms of this Capitol complex, is still a respected, honored, and deeply historic place that plays a very important role in the functioning of our Constitution and civil society. I also want to be a judge so I can continue learning and growing as a professional. I look forward to learning many new areas of law and challenging myself for the remainder of my career. If confirmed, I commit to you, the governor, my colleagues on the bench and in the bar, and all of the people of the state of Utah to be an honest, neutral, fair, strong, and empathetic judge who applies the law as it is written by the policymakers, who respects all who comes in my courtroom, and who strives to strengthen and better Utah's judicial system. Thank you, and I welcome your questions.
Thank you very much. Very much, and thank you all for being here, and thanks for your patience and getting through the first one before we got to yours. So, and I have enjoyed working with you, Derek, on the adoption bills over the years. So, all right, who would like to start us off? Senator Brammer, your light is still on. Do you want to start us off?
I'm happy to get us going. First of all, it's thank you for coming and thank you for applying and a couple of kind of different questions. Number one, on the adoption side, I've done a good amount of pro bono with foster families and helping them, and I agree with you. That final process where, for the first time, oftentimes for these foster kids, it's the first time someone's ever told them that they want them. And it's a really cool experience. So I think that's a fantastic perspective coming in that you have. My law practice is probably somewhat similar to yours in the sense that you came from big law and are now with a little bit of a smaller shop. Based on the general finances of a civil litigation shop that's smaller and the overhead on that and the likely profit margins, I'm wondering why you want to be a judge.
Fair question. My partners would have asked me the same question multiple times. And I'll just be straight with you. Money's never been the most important aspect of my career. We all need it. We all work for it. We all want it, obviously. But I got to a certain point in my career where I wanted to be challenged again in a different way. I wanted to learn new areas of the law. And frankly, I didn't want to have to start over and find new clients in a different area of law and market and do it that way. And so I was attracted to the bench in part for that reason. But thankfully, a few years ago, the legislature raised the salary for district court judges, and I think that helps to attract more private practice lawyers, and I hope that you'll consider that. I know raises for judges is probably not a high priority for the legislature right now, but I hope in the future you'll at least consider the fact that as you're able to, you'll be able to attract more of those private practice lawyers that I think would benefit the bench.
Yeah, and I think it's always been a bit of a challenge on the private practice side to, it's a job that's typically based on the pay scales more attractive coming from the public sector than from the private sector, and I get that fully. One of the things that I really like about your statement and your application in your life is, I think in a lot of ways, you're someone that does have some passion, and I would view you as, in a way, you've got some purpose and meaning. That tells me that you're a bit of a romantic in the sense that you like to, there's some passion that drives you. One of the concerns that we have from a legislative standpoint when you get a romantic judge is the idea that they're going to change the law from the bench. And so that it's a good thing, but we do get concerned about how that is channeled. And I was hoping you could tell me a little bit about judicial restraint, what that means to you and your philosophy and decisions.
Thank you, Senator. Sure. I don't know what kind of comment you got from opposing counsel that I've worked with in litigation, but I would guess that some of them may have told you that I'm definitely not a romantic when I'm in a heated deposition, when I'm cross-examining an expert witness, or when I'm arguing a motion before the court. I can be serious. I'm usually more serious, and can definitely be strong when needed. More directly to your point about judicial restraint, as a practitioner, and it's come up a lot in adoption law actually, as a practitioner, I have had many times where I have had to either explain to my client or go through a situation that was very, very difficult for me and for my clients because the law required us to do that. It was absolutely not what we wanted to have happen in that situation. It was emotionally difficult to call a couple who had been home from the hospital with a brand new baby for 6 or 7 hours, showing their new kids, the new member of their family. And I had to call them at 6:30 at night and tell them the birth mother wasn't signing her paperwork because she had been defrauded by a guy named Paul Peterson, who is a lawyer from Arizona, who's now in jail for this. And I was involved in that case, in some of those cases. And I had to stand in the bottom floor of the building downtown Snow Christensen and Martineau as that couple brought that baby back. And I held that mother in my arms, and she said, "How? Why?" And I said, "This woman has the right to be a mother, and she's not required to sign these papers. And as much as this is what we think is best for this child, the law requires that this happen, and I'm so sorry." And I held her while she cried, and I said goodbye to them, and I took the baby back upstairs, and that mother went back to the Marshall Islands with her baby. I don't mean to be overly emotional today. I'm so sorry, but my point is that I've been there, I've done it. I know how to set aside emotion. I know how to set aside personal opinions and feelings, and that's the role of a judge. I understand that fully, that my job as a judge will be to apply the law, and my personal opinion gets left back in chambers. My personal feelings of what I think should happen is irrelevant to the decision that I have to make as a judge. And I believe my private practice and my personal experiences in the law have prepared me for that, and I commit to you that I will continue to do that.
I don't have any further questions.
All right, thank you. Anyone else? Senator McKay.
Yeah. Thank you. Appreciate your testimony and appreciate you going through this process. This is certainly a fun process. I've heard from many that they really enjoy it. So
Very much. I'd appreciate it if you didn't make me cry anymore.
very difficult. Yeah, I'll tend to be more towards the law side of things.
Thank you.
Utah has a strong history of protecting religious liberty and religious freedom. How do you balance an individual's religious rights versus government regulations in situations like a public health mandate, for example?
Well, I can't speak to the specifics of a public health mandate situation because I don't have the information in front of me. I don't know what the question is that I, as a judge, would be being asked to answer. So
Let's just say that someone shows up in your courtroom and they've filed for injunctive relief and said, we don't have to follow this public health mandate because of our religious affiliation, and whatever the mandate may be, the government has said, this is what you're going to do, and the individual says, my religion prohibits this. How do you reason those two differences in the law?
Well, again, I'm not sure that I'll be able to satisfactorily answer the hypothetical you've given me, but I think I can answer the question that you're asking of me in general, which is I would first trust that the legislature has addressed this in statute.
That's way too trusting.
I know that probably is the case in a public health emergency. It snuck up on everybody. My point is I would look first there, the statutory language of number one, what mandate are we talking about, or what specific law is it that is being asked to be enforced? And number two, what is the case law applying in Utah that applies to religious liberties? What has the Supreme Court said they are, and how do those come together? And there will be a basis to make an informed decision once I'm able to study those and understand both of those together, and come to a conclusion that I would expect, given the legislative intent and history of this state, without knowing, I would just say I would expect that they would probably favor religious liberties and rights of that individual. But again, I'm obviously not offering you an advisory opinion, Senator, but I would assume that would be the direction, because I'm generally familiar with the intent of the legislature when it comes to things like religious liberties, and that they are very important in the state of Utah.
Yeah, thank you. Appreciate that insight. Let me ask further. Recently, the Supreme Court has taken up, the federal Supreme Court has taken up injunctive relief and these nationwide broad injunctions against laws that were enacted by Congress or by administrative rule or by an executive order. Let me ask you, and this debate has actually been had in Utah recently as well, about broad injunctive relief, where that prohibits the purpose of maybe a legislative provision or a law that's been granted. In what way or in what places do you feel like it is important for that injunctive relief to exist, and how do you balance the state's interest in enforcement of the law versus an individual's interest to have their right protected in that situation?
Sure.
And I'm talking about theory and philosophy more than I am dealing with the specifics hypotheticals, obviously.
All right, I'm not going to be able to escape by going with the hypothetical route then, huh?
Nope.
I think, Senator, that, well, we now have some direction and instruction from the U.S. Supreme Court on this issue that we would certainly look to determine if it's applicable and if there's guidance in there on the background principles. Again, it would depend on the statute that's being enforced. I think it's also very important to understand and for the judge to understand and study who is before them, what plaintiff, what petitioner is seeking the relief. Can it be limited to that? And my general philosophy would not be go broader than answering the question that's before me, the decision that's before me for the parties that are before me. I do not see myself as someone that has an interest in broadening a decision I make to apply to more people than those that are standing in front of me. Clearly, if it's a class action or some other broad class situation, you're going to affect bigger number of people in the decision and the injunction that you might put in place. But I think that's pretty rare where a Utah District Court judge will be asked to impose a statewide injunction, for example. I don't know that if that's happened. If it has, I'm not familiar with it. But most of the time I would be going into a decision narrowly focused on who are the parties before me, what is the legal question before me, and what's the narrowest scope of dealing with that I can make in my decision.
I appreciate that. Thank you. I think that answers my question. Last one. Did you ever work at Lagoon?
No, my son did, but I did not. We do have a familial tie to Lagoon. If that's an important factor in your vote, I can have my son come up and testify.
It doesn't weigh as heavily on me, but there are others who are very interested in making sure we keep the Lagoon Mafia rolling. So,
and I have been sitting back there in the chair studying everything I know about cheeses in my head, just in case I get a question about my favorite cheese.
Fair enough. Thank you.
Anyone else? We'll go to Senator Pitcher.
I'm curious what your experience is in dealing with pro se parties, and how would you think about how you would efficiently and appropriately handle matters in court where one or both of the parties are pro se?
I obviously haven't ever been in a case where both were, because I'm an attorney, so I would have been the one representing. I have had cases dealing with opposing pro se parties, and I've watched how judges handle it, and I've liked some of the things they've done, and I've not liked some of the things they've done. The principles I would try to follow and emulate that I've appreciated and liked are those where the judge is patient and listens to the pro se party, allows them to be heard, allows them to feel like they're participating in the process, but also explains to them the necessary rules or guides them to where they can find the necessary rules that they have to follow to go through the process. A judge can't give legal advice and shouldn't give legal advice to a pro se litigant, but they can help them find ways to get the answers themselves or resources where they can get advice if they need it in order to get through the process. I've watched online recently some either debt collection, landlord-tenant type cases and calendars, and I see that come up a lot where the judges are having to explain the process that they need to follow and where they can go to get some help answering their questions when the judge can't. And I appreciate that and like that and would seek to be that same way. The last thing I'll say is that pro se litigants should not be given an advantage over a party that has a lawyer. They should not be given longer extensions or deadlines unnecessarily that you would not give to a represented party. And they should be held and bound by the same rules of civil procedure that are followed by represented parties. We need to have consistency in the judicial process, and that needs to apply to pro se parties as well.
Thank you. And then one more. During COVID, the courts, like most entities, moved most of their proceedings onto WebEx or virtual hearings. I think as a result of that, we had some important lessons and maybe takeaways about access to justice, but also confrontation clause. And I'm wondering, from your experience, assuming you were practicing during that period, what takeaways do you find and from that, both pros and cons, and how would you implement that in your courtroom?
It's a great question. It was really, I believe, from a civil litigation practice, it was revolutionary. It changed a large aspect of our practice, in the sense that prior to the pandemic, I did a lot of traveling to depositions. I did a lot of in-person depositions with other counsel, the parties, obviously, and that all changed once we discovered through the pandemic, and a little bit before, but video conferencing and Zoom, it changed the way a civil litigation is handled now. And there are pros and cons to that. The convenience of being able to stay at the office and not travel as much reduces costs to the client, saves time for the lawyers, allows you to navigate and manage multiple hearings. As you know, as a criminal practitioner, multiple hearings that are all over the state or all over different counties and jurisdictions in the same afternoon. That's a good thing. That's a positive. I have noticed a negative effect, and that is on perhaps the camaraderie or the civility. I don't know if civility has declined, perhaps, probably not, but we aren't together as lawyers very much anymore on the civil side. We're not having lunch together. We're not traveling together to depositions. We're not, and I'm talking about opposing counsel as well as co-defendant counsel in my case. And I personally have regret losing that camaraderie and connection with other practitioners in the bar, because we're all online now. So there's some pros and cons. In my courtroom, if you're asking how I would approach that, I think it's vital nowadays for access to justice to allow, when it's possible, to allow participants to get on from home and attend their hearings. I frankly don't know the exact rules in the criminal process of when someone has to appear in person and when they have to be online. I presume I'll be taught all that and learn all of that. But my approach would be to allow hybrid hearings, where if you want to come be in the courtroom, I love arguing a motion in the courtroom. I hate arguing a motion over Zoom. I like to stand at the podium. I like to be in the environment. I like to look at the judge up on the dais. I like that environment and that part of our practice. So I'd be inclined to have hybrid hearings, where those that want to come, you're welcome to come. Those that prefer the convenience of their desk can stay at their desk.
Thank you.
All right. Senator Ipsen, would you like a turn?
Yes, I would. So I've asked this question, you probably heard me previously, and I generally like to ask it because I'm concerned about it. I'm a businessman, and I've had to be in court a lot. As you deal with cases, are you willing to reach conclusion rather than take under advisement cases of litigation with civil suits?
Yeah, Senator, thank you, and I understand your position. I've represented large, medium, and small businesses and business owners, as well as individuals and young families. And as much as they may like me, and as much as you may like your lawyer personally, none of my clients have ever wanted to pay for a lawyer 1 second longer than they needed to. And most of the time, I get a doctor that says, "Thank you, I really liked working with you. I hope to never see you again." And I don't take it offense, but the principle is real. It's a real issue, Senator, and it's something that I hope that our judicial system can figure out how to address, and that's the rising costs of litigation. I recognize the importance of moving a case along. I I do believe in my experience in the civil litigation context, it is very much dependent on the lawyers. I don't see as often where it's the judge that's dragging a case along as much as it is the lawyers that are agreeing to a 5th, 6th, 7th, or 8th amended case management order. And because they need to get the work done and their schedules don't match and there's 8 different law firms that have to be coordinated, that's a nightmare to coordinate the schedules for depositions, for experts, for things like that. And so as much as it is in the control of the judge, and your point is well taken, that when deciding a motion for summary judgment, a dispositive motion that could end the case, it's vitally important that the judge do that in an expedited manner. It could make the difference of months. And I would plan and work to be prepared when the time comes for oral argument so that I can be prepared to address the question that day if at all possible. I've seen it happen a few times recently where I've been in court with a judge and watched it online. Judge Keith Kelly, whose position I may be taking actually, is very good at doing this. He'll come to the hearing prepared, he'll listen to oral argument, and then he'll pause and say, I need to take a few minutes in chambers, and he'll leave the bench and go back for 10 minutes, 15 minutes, 20 minutes if needed. He's gathering his thoughts, he's making his notes, and he comes back right then and issues a well-articulated and well-reasoned decision and is done. And I like that approach, and I would be in favor of using that as much as I could. Obviously, there are some very complex motions and decisions that are going to require additional law clerk time and writing lengthy decisions and things that can't be done at the same day. But in general, I agree with your sentiment that we need to move the cases along if at all possible.
Thank you. One other question, and same thing is, are you prepared for the loneliness? Or if it might be couched that way, as your family becomes somewhat isolated from the rest of the community?
Well, the answer is yes. I will say nobody in this world will ever be able to keep my wife from socializing and making friends.
That's good.
And so that will never change. I'm a little bit more in the background. I'll be okay if I don't make a lot of new friends. And if it means I get to spend more time with my family, then I'll be just fine with that.
Great answer. Thank you. Your wife liked that too.
All right, thank you, Senator Ipson. Senator Cullimore, did you have any questions?
I'll come up with one for sport. Having practiced in the district courts and now potentially joining the district courts, what's one thing that you might like to see changed at the district court level?
That's a good question. Well, to be honest, I think I'd be able to better answer that after I've been in the district court on the bench for a period of time. But as a practitioner from the outside, a couple of things that I would like to see changed would be, and I'm not super intimate with the family law. I do have a little bit of exposure. It's an adjacent practice to adoption law, obviously, and I've been watching and observing more recently, and my firm has a family law practice out in Vernal that I've dabbled in. The delay from the start of a divorce case to the entry of temporary orders seems extraordinarily long, and getting some stability to the divorcing parties earlier and quicker, I think would be really helpful. I have no idea what the answer is on how to do it, but that's an observation from an outsider that both has seen it a little bit in practice, but have seen it as somebody going through a divorce that might wait months to know what are the rules regarding the kids and when they're going and coming and things like that. That's something that I think could be changed. The other would be the increasing costs, as I spoke about with Senator Ipson, the increasing costs of litigation. We have indigent defense resources. We have resources for the poor, and we have insurance companies and businesses for the higher class and the businesses. We have a middle class and an upper middle class that it's very difficult to afford to pay someone $200 to $500 an hour to litigate a lengthy case. I couldn't, many of you probably couldn't, and we're lawyers, right, afford to hire ourselves for a 2-year litigation and pay a lawyer at $250 or $300 a month. And there's a pressure to increase the billable hour every year because costs are going up for the firms and for the lawyers, and we need to cover those and still make money as a lawyer. And so we have to increase our hourly rate. And so I just see the hourly rate and billable hour continuing to be an issue that's going to complicate justice for a lot of people in our society. I think that
All right, thank you.
staying in
How
their
do you-
lane
how
is-
do you,
is sort of a short way to say it.
I'm going to skip that one. In your view, what does a healthy separation of powers among the branches of government look like?
I think that each one staying in their lane is sort of a short way to say it. That's a cliche phrase we use nowadays, stay in your lane, right? And it's recognition that the Constitution, our government, is established in a certain way. The legislature is the policy-making body. They report to and answer to the public, to the people, and that's who sets the policy for the state. The judiciary's role is to, I've heard it said, the judiciary looks backwards, and it's the legislature that looks forward. So the judiciary should look at the law that's in place and apply it, not be looking forward at how we can anticipate the future or change things for the future from the bench. And so recognizing and understanding the role of a judge, the role of judiciary to resolve the disputes in front of them and leave policy making or changes to the law to the policy making body, which is the legislature.
Thank you. Former Supreme Court Chief Justice Christine Durham described the Utah Constitution as, and I quote, distinctly undistinctive due to its reliance on provisions from other states. Apparently there was a lot of cut and pasting going on in the late 1800s. Considering that history, how much weight would you give to precedent from other states and federal courts when interpreting provisions of the Utah Constitution?
Well, as a general matter, I would, my instinct is to say it would have very little weight. We have statutes, we have constitutional provisions here in Utah, and we start there. And if it's a constitutional provision, we look at the words, the plain reading and language, and if there are supporting or enabling legislation or statutes on the subject, then we're going to look to the language of those statutes to determine how to answer the question. I think that one would have to get very, very, very far down on the list of judicial resources in order to begin looking at other states. There's just too many differences between states and why and how they came up with their particular statutory or constitutional provisions that would make it a meaningful use, in my opinion.
All right, thank you. How would you determine when a particular issue before the court is a political question and therefore non-judiciable, I can't say that today, justiciable to decide?
Well, it would depend on the question, the motion, the legal question that's before the court. And it would be similar to, I put sort of political issues in the similar vein as personal opinions, or who's my favorite college football team, And is their rival before me in court today, and does that matter? No, it doesn't, right? So political questions should never come into play in a courtroom. Do judges have to decide legal questions and answer legal disputes that involve what the media or the public or what you as legislators deem to be political? Absolutely. That does not change or influence the role of the judge in the process. The judge needs to look at the legal question before him. The findings of fact are going to be based on the evidence that is entered into the case, and the legal decisions will be based on the law and the wording of the law that's at issue. And a judge should disregard any of the other noise that's irrelevant, in my opinion.
Thank you very much for that. Do you believe the court should recognize new rights that are not expressly provided for in the state constitution? I'm talking, again, not federal but state issues.
Without knowing the question specifically before me in general, no, I do not believe it's the role of a judge to read in any new rights or any expanding any laws beyond what is written and provided already.
Thank you very much. Do you have a judicial role model, someone that you've appeared before that you would hope to emulate on the bench?
I don't. I don't have a specific name or person. I have qualities that I've taken from a lot of different judges that I would like to emulate. I've honestly thought of this question, and I really don't have one particular person that I would give you. I appreciate the temperament, the patience of a judge that will listen to the arguments, listen to the participants in the courtroom, allow them to be heard, allow them to feel like they're have been part of the process and that they got to say what they want to say. One of Stephen Covey's core principles that I like to live by is seek first to understand and then to be understood. It's really important for people to feel valued as they're going through the process, and so listening and hearing what people are there to say is important. I also appreciate a judge that makes a decisive decision. There's nothing more frustrating as a litigant, as a practitioner, to have judges that are inconsistent, that you never know whether they're going to do this or that. Are they just going to split the baby again because they don't want to make the hard decision? That's frustrating, and I would hope to be a judge that's not afraid to make a decision, right or wrong. You'll get a decision from me, and it'll be decisive, and I like that quality in a judge, and those are a couple examples that I would try to emulate.
Thank you. And a repeat from the last go round. What do you feel like your greatest accomplishments and your greatest regret are or is in your legal career?
Well, I think you heard from my statement. My greatest accomplishment has been the work I've been able to do for many hundreds of Utah families in the adoption field. It's simple but it's meaningful, and I certainly have enjoyed getting to know and representing and defending our healthcare providers in Utah. We have really very strong and good doctors, nurses, and providers, and I'm proud of the work I've done to defend and protect our medical industry. In terms of regrets, a little bit like Amanda, I don't harbor on the past very much. I don't spend a lot of time thinking about and stewing over a mistake I've made in the past. If you say you're not going to call a vote until I come up with one, then I would say that I probably would have liked to have worked less hours as a private practitioner and had more time available with my family.
So speaking of your family, we're not going to call Allie or Ian to testify, but what would they say if we did about your fairness in administering discipline and whether you hear them out first before you make a decision?
Well, you probably saw that look on Ian's face. I could see it right here on the screen. I don't know what they would say. I hope they would say that I did my best, that I tried my hardest, and that I disciplined them based on their individual circumstances and ages and timing, and that I didn't, I certainly did not parent them the way I was parented in the 80s and 90s, that's for sure.
I can relate to that. What role do you believe a judge should play in the community outside of the courtroom?
I think that Utah and every state, but particularly in Utah, I would like to see more education of the public. And I'm again not sure quite how to do this. I've been involved. I took a gap off for a number of years, but I spent many years and then just started back up again this year, acting as a judge or serving as a judge for the Law-Related Education Project and the junior high and high school mock trial competition that's held every spring. And I've loved that. Teaching and educating youth, but the public in general, about how a lawsuit works, how a trial works, how dispute resolution works in our court system. Figuring out how to educate the public or teach or expose them more to the real judicial process could help combat some of the negative assumptions that are made in our fast-paced world of social media, where people read something and then make an assumption and an opinion and a decision about a situation or a judge or a politician or anybody without the facts or without understanding and knowing what went through to get to that point. More education, I think, would be great. And if there are opportunities where I could participate in doing that, I would welcome that chance in the community to do that. Other services allowed under our rules of ethics. The more that people can see that judges are out in the community and are real people, and I think would be better.
What role, if any, do you believe alternative dispute resolution should play in Utah's court system?
It's an important role. I think that I have mixed feelings about it as a civil litigator. Most judges nowadays have a mandatory ADR requirement before they'll give you a trial date. And if you're done with expert discovery and you're ready for trial and you've gotten that far in the case and it's not settled or resolved by that point, usually a judge forcing you to mediation in order to get a trial date is not going to change the case that often. But I understand why they do that. They don't want to take the jurors' times, call in jurors. If you're going to settle the night before trial, that's very frustrating to the system and to judges, and I get that. And so I understand the reasoning behind it. I think that if there's no sign of any attempts at mediation and we're getting close to the end of the case, I would encourage that or inquire about that. And if necessary, if one party asks, I'm not afraid to enter an order to give them a shot at that. I think ADR has its place. Where it could be misused sometimes is when a judge has I don't see it that much, but I've heard of it being used where a judge may have a sticky motion pending or a dispositive issue, and they want to avoid, for appellate purposes or something, making that decision, and they'd rather the two parties get it resolved instead, and so they push that more. And I wouldn't agree with that approach to dispute resolution.
All right, my last question. How would you demonstrate a commitment to fairness to the parties in your courtroom?
I think fairness is not did they win or lose. I think that's I think that's what we call justice. Justice is the outcome that are required by law. Fairness is, how did you treat the parties as they went through that process? Did the parties feel heard? Did they feel like they were treated fairly under the rules of civil procedure or criminal procedure? Did they feel like you listened and that they got to express their views and their positions adequately? And did they feel like they were given an opportunity to fairly present their case? I think that's where fairness comes in. How did they feel when they leave your courtroom, as opposed to what outcome did they get? And so that would be my general approach to fairness in the courtroom. We can jump into Senator Kwan's bias question and biases and things like that, and certainly we all have them, and we have to be aware of them and not allow those to improperly influence our decisions. And I think being aware and educated of one's biases is the key to that. But that does affect fairness. If you improperly allow inappropriate biases to influence the way you treat someone, then that's completely improper, in my opinion.
All right, thank you. Any follow-up questions from anyone on the committee? Thank you. Then Chair will entertain a motion if anyone's so inclined. Senator McKay.
I'll just make a motion that we favorably recommend Mr. Williams for confirmation of the full Senate.
All right, we have a motion to favorably recommend the nomination of Derek Williams to the 3rd District Court. Discussion to that motion. Seeing none, all in favor say aye.
Aye.
Aye. Senator
Aye.
Epson? Oh, any opposed? Chair rules that passes.